You've seen it 100 times. On television, in movies, on the chaotic streets of a viral video. A person, flush with defiance, squares their shoulders, looks an officer in the eye, and declares with absolute certainty, "I know my rights." It's the modern mantra of the legally empowered citizen. It feels powerful. It sounds invincible. It is, in the vast majority of real-world situations, the single fastest way to turn a manageable situation into a life-altering legal nightmare. This is not a dramatic overstatement. It is the daily reality observed from behind the defense table. The gravest mistake is not ignorance. It is the profound, often arrogant misunderstanding of how rights function in the friction-filled atmosphere of a street encounter, a police inquiry, or a courtroom. This belief, this "I know my rights" reflex, routinely ruins lives that could have been preserved with silence, respect, and strategic compliance. This article is a journey into that gap, the cavernous void between what people think they know about their rights and how those rights actually operate in practice. We will dissect, in exhaustive detail, the legal principles, the human psychology, and the tactical realities that define encounters with authority. We will move beyond the slogan and into the machinery of the justice system, a system that cares little for your performative declarations and everything for procedure, evidence, and the cold, hard facts of the moment. Our purpose is not to make you a lawyer, but to give you the survivor's manual for the legal system, a guide that prioritizes your long-term freedom and well-being over the short-term satisfaction of a rhetorical victory. We begin with the foundational flaw, the myth of the magic words. The popular imagination believes that rights are incantations. Say the right phrase, "I plead the fifth," or "I do not consent to a search," and the system's gears grind to a halt, the officers retreat, and your autonomy is preserved. This is a dangerous fantasy. Rights are not shields that materialize upon utterance. They are procedural protections that are enforced, often imperfectly, and after the fact, in a courtroom. An officer does not violate your Fourth Amendment rights at the moment he conducts an illegal search. He may be found to have violated them months later by a judge. In the interim, you are arrested, jailed, charged, and forced to navigate a complex and expensive legal process. The magic words do not stop the encounter. They often escalate it. Your legal victory, should it come, will be Pyrrhic, paid for in time, money, stress, and a permanent record. Let us take the most common scenario. The traffic stop. You're pulled over for a minor infraction, a taillight, a rolling stop. The officer approaches. You, armed with internet knowledge, immediately state, "Officer, I do not consent to any searches." The dynamic shifts instantly. What was a routine stop for a traffic violation becomes, in the officer's mind, a potential investigation. Your assertion of rights is interpreted not as legal literacy, but as indicia of guilt. Why, the officer thinks, is this person so concerned about a search if they have nothing to hide? This is a legally flawed perspective. You are absolutely correct in principle, but it is a universal human one. The officer may now prolong the stop, call for a K-9 unit, and ask increasingly intrusive questions, all in an effort to develop reasonable, articulable suspicion to escalate the encounter. You may win a motion to suppress the illegally found drugs 2 years later, but you will have lost nights in jail, thousands in legal fees, and possibly your job. This leads to the cornerstone principle of all street-level encounters. De-escalation is a legal strategy. Your primary goal in any interaction with law enforcement is not to prove a point, not to educate the officer, and not to stand your ground for the sake of pride. Your sole, overriding goal is to go home safely and free, with as little legal entanglement as possible. This often requires strategic, polite compliance, even in the face of provocation or uncertainty. Answering basic, identifying questions, "What is your name? Do you know why I pulled you over?" is typically required by law and does not implicate your Fifth Amendment rights in a meaningful way at that stage. Arguing about the legality of the stop on the roadside is a futile exercise. The side of the highway is not a courtroom. The officer is not a judge. Your lawyer's battlefield is the motion hearing, not the asphalt. Now we must confront the most sacred and misunderstood right, the right to remain silent. Everyone knows the Miranda warning, but here lies a catastrophic common error. The Fifth Amendment right to remain silent is only procedurally protected. meaning it cannot be used against you at trial if you unambiguously and affirmatively invoke it. Simply remaining silent is not enough. The Supreme Court has ruled that silence, in the face of police questioning, can sometimes be used as evidence of guilt if you have not clearly stated you are invoking your right. The correct, powerful, and essential phrase is, "Officer, I am invoking my right to remain silent, and I wish to speak to a lawyer." Then, you must actually remain silent. Not another word. Not, "Am I free to go?" Not, "This is ridiculous." Nothing. Any subsequent speech can be construed as waiving your earlier invocation. The mistake is believing your silent glare is legally operative. It often is not. Consider the interrogation room. You're arrested, scared, and alone. You know you're innocent. You believe truly that if you just explain yourself, the misunderstanding will clear up. This is the siren song that has convicted more innocent people than any other. The interrogation is not a truth-finding mission. It is a guilt-confirming process. The techniques, the Reed method, minimization, fabrication of evidence, the good cop, bad cop routine, are scientifically designed to break down your resistance and elicit a confession, even from the innocent. Your desperate, rambling explanation for why you were near the crime scene will be dissected, twisted, and used to create inconsistencies that paint you as a liar. At this moment, your "I know my rights" bravado means nothing. The only right that matters is the one you must invoke and then cling to with monastic discipline, the right to an attorney. The moment you ask for a lawyer, all questioning must cease. There is no loophole. It is the most powerful tool in your arsenal. Yet, people wave it every day, convinced of their own eloquence, only to find their own words forged into the bars of their cell. Beyond the police encounter, the "I know my rights" fallacy extends into the courtroom and legal negotiations. Pro se representation, representing yourself, is often the final tragic act of this fallacy. I know the facts of my case better than any lawyer. This is true, but law is not about facts. It is about the rules of evidence, procedural deadlines, complex motion practice, and strategic negotiation. It is a language you do not speak and a game you do not know how to play. The judge is not your advisor. The prosecutor is not your adversary in a debate. They are a professional whose goal is to secure a conviction, and they will exploit every one of your procedural missteps. Your right to represent yourself is, as one justice famously noted, the right to plead your case out of court. It is almost always a disaster. Let's talk about the Fourth Amendment and consent. The principle is simple. You have a right to be free from unreasonable searches and seizures. The reality is messy. Do you know the contours of a Terry frisk versus a full search? Do you understand the plain view doctrine, the automobile exception, or what constitutes exigent circumstances? An officer asks, "Mind if I take a look in your trunk?" You, believing you have nothing to hide, say, "Sure." You have just voluntarily waived your Fourth Amendment rights. The subsequent search, even if it finds contraband, is perfectly legal. Your later protest of, "I didn't know I could say no," is legally irrelevant. Ignorance of the law may be no excuse for a crime, but ignorance of your rights is their most effective nullifier. The strategic response is a polite, "Officer, I do not consent to any searches." Be prepared for the consequences of that statement, but know you have preserved a critical legal challenge for your attorney. Here is the suspense-driven question I want you to ponder. You are in your home, and police officers knock on your door. They are friendly, but ask if they can come in and ask a few questions about a crime in the neighborhood. You have nothing to do with it. You know you don't have to let them in without a warrant. But what is the single, most likely, immediate consequence of you firmly stating, "I do not consent to a warrantless entry," and closing the door? Will they A, simply leave and continue their investigation elsewhere, B, immediately go get a warrant, or C, use your refusal as grounds to detain you right there while they secure the warrant? The answer, which hinges on a critical legal concept, may determine the next 24 hours of your life. Think about it, and I'll share the realistic outcome later. We must also dismantle the digital version of this mistake. In the online world, people believe their rights are suspended. They make incriminating statements on social media, in text messages, and in emails. They speak freely to friends who are cooperating with the police. They believe, absurdly, that delete means destroy. Every digital footprint is a potential witness. Your right against self-incrimination applies to compelled testimony, not to your voluntary, boastful Instagram post about activities that could be construed as criminal. The prosecutor will subpoena your records, and your private messages will become Exhibit A. In the digital age, the most common way you violate your own rights is by tapping Send. So, what is the alternative to the defiant, self-sabotaging declaration of, "I know my rights"? It is the practice of quiet, strategic competence. It is, be polite and calm. Emotion is your enemy. Anger, fear, and sarcasm cloud judgment and provoke escalation. Identify the nature of the encounter. Are you being detained? Are you free to go? You may ask calmly, "Officer, am I being detained or am I free to leave?" Comply with lawful orders. If you are being detained, you must comply. Resistance, even to an unlawful order, is a separate crime. Fight it in court, not on the street. Invoke, don't pronounce. Don't give a lecture. Use the clear invocation phrases. I am going to remain silent. I want a lawyer. Document everything. After the encounter is over, write down every detail: officer badge number, car number, and witness contact info. This is gold for your attorney. Secure an attorney immediately. This is not an admission of guilt. It is the single smartest investment you can make in your own future. A lawyer is not a mechanic you call after the engine explodes. They are the co-pilot who helps you navigate the storm. The legal system is not fair. It is not designed for fairness. It is designed for process. It is adversarial, confusing, and weighted with immense power. Your pop culture understanding of your rights is a map that bears little resemblance to the treacherous terrain you must cross. The true experts, the lawyers, the judges, the seasoned officers, understand this. They see the "I know my rights" individual as the easiest mark on the board, the person who will confidently walk into every trap. To return to our suspenseful question, the most likely outcome when you deny consent to a home entry is B or C, with C being a strong possibility. Officers do not need your consent if they have probable cause to believe evidence is inside and that it may be destroyed. Your refusal of entry itself can contribute to their argument for exigency, that evidence is at risk. They can secure the perimeter, detain you and anyone else present to prevent destruction of evidence, and rapidly obtain a telephonic warrant from a judge. Your lawful assertion of your right became the catalyst for a much more serious and intrusive police action. This is the hard truth. Exercising a right has consequences. The strategic calculation might be different if you are certain of damaging evidence inside. The point is, there is no risk-free, consequence-free application of rights. Knowledge is not power. Nuanced, strategic understanding is. This is the mistake everyone makes. They believe rights are swords to be wielded, when they are, in reality, fragile shields to be carefully positioned. They believe the law is about what is right, rather than what is provable. They believe their understanding is sufficient. It is not. The goal is not to win the argument on the street corner. It is to survive the process with your life and liberty intact, so that your attorney can fight for you on a field where the rules actually matter. Your education begins with the humility to admit that what you don't know can hurt you permanently. It continues with a commitment to learn not just the words of your rights, but the music of the system in which they are played, a system that is often dissonant and harsh. Share this knowledge. Discuss these scenarios with your family. The cost of the "I know my rights" mistake is measured in lost years, broken families, and squandered futures. Don't let pride be the price of your liberty. If you found this deep dive into the reality of your rights valuable, and you want to learn more about how to practically navigate legal dangers, from contracts to courtrooms, make sure to subscribe to the channel. Your subscription ensures you don't miss our next detailed guide, where we'll be deconstructing the real power of a subpoena and how to respond without self-incrimination. Knowledge is your best defense. Stay safe, stay informed, and we'll see you in the next video.